Hey everyone, on February 23, 2011, the United States Attorney General Eric Holder announced in a letter to the Speaker of the House, John Boehner, that the Obama administration would no longer defend Section 3 of the Defense of Marriage Act against court challenges. The Defense of Marriage Act, or DOMA, as it's popularly referred to, is a federal law passed by the 104th Congress and signed into law by President Bill Clinton in September 1996. Back in 96, it appeared that the state of Hawaii was going to extend the legal right to marry to same-sex couples, which freaked a whole lot of people out at the time and eventually led to the enactment of DOMA. The statute accomplishes two things. First, Section 2 provides that no state shall be compelled to recognize, quote, any public act, record, or judicial proceeding of any other state respecting a relationship between persons of the same sex that is treated as a marriage under the laws of such other state. So what's that about? As part of the effort by the framers of the United States Constitution to, quote, form a more perfect union, they inserted a provision which has come to be called the Full Faith and Credit Clause, requiring each state to recognize the public acts, records, and judicial proceedings of every other state. With respect to marriage, this means that if a couple gets married in, for example, New York, and subsequently moves across the river to New Jersey, the couple is just as married in New Jersey as they were in New York. New Jersey, and every other state for that matter, is constitutionally required to recognize the couple's lawfully entered into New York marriage. Section 2 of DOMA purports to relieve states of this obligation with respect to same-sex married couples. So, for example, if a lesbian couple gets married in Massachusetts, one of the states that allows same-sex couples to marry, and the couple subsequently moves to Florida, one of the states that does not allow same-sex couples to marry, Florida is not required to recognize the couple's lawfully entered into Massachusetts marriage. Section 3 of DOMA sets forth federal legal definitions of the words marriage and spouse, defining them respectively as, quote, a legal union between one man and one woman as husband and wife, and, quote, referring only to a person of the opposite sex who is a husband or a wife. In other words, pursuant to Section 3 of DOMA, the federal government and its laws recognize only the marriage of opposite-sex couples, regardless of whether a same-sex couple was legally married in their state. It is this portion of DOMA, Section 3, that the Obama administration announced it would no longer defend in court the federal definitions of marriage and spouse. The Attorney General said that the president had come to conclude that, quote, Section 3, as applied to same-sex couples legally married under state law, is unconstitutional. In other words, it's unconstitutional for the federal government not to recognize the lawfully entered into marriages of same-sex couples in states that allow them to marry. Therefore, the Attorney General said, quote, the President has instructed the Department of Justice not to defend the statute. The Attorney General added that while the administration would no longer defend Section 3 of DOMA, the President would continue to enforce it. Quote, Section 3 will continue to be enforced by the executive branch. The President has instructed executive agencies to continue to comply with Section 3 of DOMA, consistent with the executive's obligation to take care that the laws be faithfully executed unless and until Congress repeals Section 3 or the judicial branch renders a definitive verdict against the law's constitutionality. Within moments of the Attorney General's announcement, and continuing ever since, America's right-wing media outlets and its conservative Sanhedrin began to ring the bell of alarm with a clapper of lies and misinformation.
Now he says that he is not going to enforce the law. He has made Congress irrelevant when it comes to the Defense of Marriage Act. He says, we're not even going to defend this anymore. Well, wait a minute. That's not even constitutional.
I can't let you go without asking you about this breaking news we started the show with, which is now the administration has decided to declare that the Defense of Marriage Act, which declares marriage defines marriage as between a man and woman, signed by President Clinton, they have declared that that is unconstitutional and said that they are no longer going to enforce it.
It's beyond belief, Megyn. It's beyond belief. We are a nation of laws, not of men. We are governed by the rule of law. And what the Constitution says is that the President of the United States doesn't get to decide which laws he likes and which ones he's going to enforce. He is the chief executive. The law is on the books, the Defense of Marriage Act. It is his responsibility under the Constitution to enforce that law. To me, that is a form of dictatorship. That is Mubarak Obama.
He swore an oath on the Bible to become president, that he would uphold the Constitution and enforce the laws of the United States. He's not a one-person Supreme Court. The idea that we now have the rule of Obama instead of the rule of law should frighten everybody. I believe the House Republicans next week should pass a resolution instructing the president to enforce the law and to obey his own constitutional oath. His job is to enforce the rule of law.
And that's their role. That's their job. That's the Attorney General. Enforce the law as it's written. Choice. They don't get to write it themselves.
Correct.
But why do we have the legislative branch? Why do you have presidents that sign these bills?
That's right. But then they're going to enforce the law across the country. That's what
when they say they're not going to defend it, they're not going to enforce it.
The truth, facts, do not matter to these people, not in the least. As you've seen, the administration has unequivocally stated that it will continue to enforce Section 3 of DOMA unless and until it is either repealed by Congress, and there's been legislation introduced to do that, or definitively ruled unconstitutional by the judicial branch. Here's the president's press secretary.
It's also important to note that the enforcement of the Defense of Marriage Act continues. The president is constitutionally bound to enforce the laws.
Attorney General Holder wrote, quote, "This course of action respects the actions of the prior Congress that enacted DOMA, and it recognizes the judiciary as the final arbiter of the constitutional claims raised." Interestingly enough, some of the great icons of the conservative movement, not President Obama, have argued that a president has not only the right, but indeed the duty not to enforce a law he or she deems unconstitutional. Just a few examples. James Wilson, signer of the Declaration of Independence, delegate to the Constitutional Convention from Pennsylvania, framer of Article 3 of the Constitution, and appointed by President Washington to the United States Supreme Court, regarded by some as the second most influential member of the Constitutional Convention behind James Madison, said, quote, "The President of the United States could shield himself and refuse to carry into effect an act that violates the Constitution." Supreme Court Justice Antonin Scalia, a conservative darling, in his opinion in the 1991 case Freitag v. Commissioner of Internal Revenue, said that among, quote, "the means available to a president to resist legislative encroachment is the authority, quote, even to disregard a law that the president deems unconstitutional." President Ronald Reagan, whose haloed image conservatives would put on Mount Rushmore if they could, refused to enforce portions of the Competition and Contracting Act of 1984, a piece of legislation, by the way, that he had signed into law as president. And through his attorney general, Reagan ordered agencies of the executive branch to ignore those provisions of the law because Reagan believed they were unconstitutional. Conservatives and their icons have argued that a president may refuse to enforce a law that he or she believes to be unconstitutional. But you will never hear even one of these right-wing gasbags screeching about Ronald Reagan's refusing to enforce provisions of federal law. You will never hear one of them condemn Antonin Scalia for declaring that the framers of the Constitution gave the president authority, quote, to disregard a duly enacted federal law when the president has determined that it's unconstitutional. Yet they lie and heap criticism on President Obama, who, unlike Ronald Reagan, is enforcing the law while awaiting either congressional repeal or a dispositive judicial determination of its constitutionality. These conservatives do not care about the truth. Conservative lies and bullshit aside, a couple of important, interesting, and complex questions should be asked. The first, is it legal for a president to refuse to enforce a law he or she believes to be unconstitutional? Constitutional scholar Neal Devins of William and Mary has noted that, quote, out of respect for both Congress's lawmaking prerogatives and the judicial power to interpret the Constitution, Office of Legal Counsel opinions. I should break in here just to say that by delegation from the United States Attorney General, the Office of Legal Counsel provides the President and all executive branch agencies with authoritative legal opinions. Professor Devins notes, quote, that out of respect for both Congress's lawmaking prerogatives and the judicial power to interpret the Constitution, Office of Legal Counsel opinions allow for a president, as a matter of prudence, to enforce constitutionally suspect legislation. Professor Devins continues, quote, according to these opinions, the president should execute, that is to say, enforce the statute, notwithstanding his beliefs about the constitutional issue. And this, as we've seen, is the course President Obama is taking with respect to Section 3 of DOMA. But there is disagreement among lawyers and scholars about whether the president's constitutional duty, quote, to take care that the laws be faithfully executed, obligates the president to enforce all federal laws, even ones he believes to be unconstitutional. After all, the president's constitutional oath of office obligates him to, quote, preserve, protect, and defend the Constitution of the United States. And the Constitution is, by its own terms, quote, the supreme law of the land. Frank Easterbrook, conservative chief judge of the United States Court of Appeals for the Seventh Circuit, a Reagan appointee, puts it this way, quote, for the president must take care that the laws are executed. Is the Constitution a law? If so, then the president must execute it too. In any contest between statute and Constitution, the Constitution wins. Judge Easterbrook, pointing to the aforementioned language in the presidential oath of office, exclaims, there's nothing there about executing laws while ignoring the Constitution. Suppose Congress passed a law requiring that all African Americans must immediately be enslaved. The president could certainly veto the law, but let's assume that Congress overrides the president's veto and this slave legislation becomes law notwithstanding the president's veto. Now, the 13th Amendment unequivocally provides, quote, neither slavery nor involuntary servitude shall exist within the United States. Would the president be required to enforce this unconstitutional law unless and until it was declared unconstitutional by the judicial branch? It's an extreme case, to be sure, but there's no in-kind difference between it and any other unconstitutional law. This is a far more complex question than some would allow. I tend to favor the above-described approach recommended by the Office of Legal Counsel, though I would say in light of the Take Care Clause, it's something more than a matter of prudence. However, many presidents, Republicans and Democrats, have at one time or another refused to enforce laws that they regarded as unconstitutional. And I must concede that it's not difficult for me to imagine scenarios, the slavery law being one of them, in which I would say a president should refuse to enforce such a law. The second question, is the president obligated to defend all federal laws against legal challenges in court? My position on this, one might say, has evolved somewhat in the wake of the debate about the Obama administration's defense of the now repealed Don't Ask, Don't Tell law. In my Don't Ask, Don't Tell video, I argued, in part, that the president's duty to take care that the laws are faithfully executed includes an obligation to defend a federal law against legal challenge. What I did not emphasize then, and wish to emphasize now, is that this obligation to defend obtains only as long as there are reasonable legal arguments to be made in court in favor of a challenged law. Despite my opposition to Don't Ask, Don't Tell and my conclusion that it was unconstitutional, I continue to believe that there were reasonable, good faith legal arguments to be made in its favor in court, and therefore that the administration was obligated to defend it against legal challenge. By contrast, in the instant case, I can't think of any reasonable, good faith legal arguments that can be made in favor of Section 3 of DOMA. In the American constitutional system, marriage is, and always has been, a matter of state law. For federal purposes, whether a couple is married depends on whether they are considered legally married in their state. The federal government has always recognized marriages from the several states, even though their marriage laws differed. The federal government even recognizes common law marriages in the few states that still have them. I can think of no reasonable legal argument for the federal government to refuse to recognize marriages of same-sex couples lawfully entered into in the states that allow them. For the federal government to treat legal same-sex marriages differently from all others is a textbook case of denying equal protection of laws and, it seems to me, an unconstitutional governmental burden on these couples' right to marry as recognized in their states. Also, look at Windsor, the United States, a challenge to Section 3 of DOMA currently pending in the Federal District Court for the Southern District of New York. Here's a couple, Edie Windsor and Thea Spire, that was together for 44 years, engaged to be married for 42 of those years. In 2007, when it became legal for same-sex couples to marry in Canada, they went to Canada to marry, and their marriage was legally recognized by the state of New York. When Thea died in 2009 after a 30-year battle with multiple sclerosis, she left, as spouses do, everything she had to Edie, her partner and spouse of 44 years. Because of Section 3 of DOMA, Edie was slapped with a $350,000 federal estate tax bill. The federal government treated Edie as if she and her dead spouse had been strangers all along. Every single surviving spouse of an opposite-sex marriage in the United States, every single one of them, is exempt from this tax for estates worth up to $3.5 million, which is the vast majority of estates in this country. The only reason Edie didn't enjoy this exemption was because her dead spouse happened to be another woman. The Obama administration looked at this case and, quite correctly, concluded, we got nothing. So, is the president obligated to defend all federal laws against legal challenges in court? Yes, I believe he is, as long as there is a reasonable, good-faith legal argument to be made in favor of a challenged law. Section 3 of DOMA presents one of those rare cases in which there is no reasonable legal argument to be made. Contrary to the hysterical screeching and lies coming from the right wing, it is not unprecedented for American presidents to refuse to defend a federal law in court. For example, Ronald Reagan refused to defend, in fact his administration challenged, provisions of the Competition and Contracting Act of 1984 and the Immigration and Nationality Act that Reagan believed to be unconstitutional. George H.W. Bush, on advice from now Chief Justice John Roberts, refused to defend a provision of the Cable Television Act of 1992 that Bush believed to be unconstitutional. Robert Bork, when he was Solicitor General in the Nixon administration, wrote, quote, "It would seem to me not only institutionally unnecessary, but a betrayal of profound obligations to the court and to constitutional processes to take the simplistic position that whatever Congress enacts, an administration will defend." In sum, for all of the aforementioned reasons, the Obama administration has made the correct decision vis-a-vis Section 3 of DOMA. There are no reasonable legal arguments to be made in its favor. Therefore, the president is not obligated to defend it. Thanks a lot.